understanding under 719A, when I read Section 1, deadly weapon, because you both have referred to firearms, is it your understanding, Roger, that this also would apply to knives?
Madam Chair, Representative McLane, it is, deadly weapon is defined in Oregon statute, and it includes, as you can see in the bill, actually, any instrument, article, or substance specifically designed for or presumably capable of causing death or serious injury. So obviously that would include knives, potentially clubs, many things.
Would it include a baseball bat?
Madam Chair, Representative McLane, I think that would be up to interpretation. It does say specifically designed for. I don't know the baseball bat is specifically designed for inducing physical injury, but certainly couldn't be used for that.
Well, it certainly is used for that and has killed people before, and it's certainly designed to swing with a hand, with hands, to be able to swing and apply force. And you could say, well, it's intended to apply it on a baseball. But my point is, part of your opposition is that this goes way beyond firearms. Okay, second of all, if you could, another question I had, I noticed that on page 3 of the bill, under Section 6, when it talks about the court's finding, which you had mentioned, Section B, it says, upon making the findings described in paragraph A of this section, the court shall issue an extreme risk protection order prohibiting the respondent from having in the respondent's custody or control, owning, purchasing, possessing, or receiving, or attempting to purchase or receive a deadly weapon. Now, I know Mr. Starrett referred to a brother in New Jersey. If a respondent owns, due to inheritance, firearms, knives, whatever, sword from a Japanese samurai, and that's being stored at a relative's house somewhere else, is it your understanding that Section B would preclude them from having ownership of a deadly weapon during the time of it, even though it may be 3,000 miles away?
Madam Chair, Representative McLane, yeah, it clearly says that you're not allowed to own any deadly weapon. So,
okay, and that's how I read it too. I just want to know, someone who opposes the bill, if you also read it the same way, because we're making a legislative history here for when the court challenges, which will surely happen, have some legislative history to deal with. Third question, I'm sorry, may I follow up?
Yeah.
Thank you. I also noticed that under Section 2, this applies to someone who is not suicidal. Someone could be not suicidal at all, isn't that correct? Meaning under Section 2, it says that someone threatens use of physical force against another person. And because of the word "or" through this section, do you also read this as applying to someone, meaning someone who is not suicidal but has shown a propensity for violence and is showing a risk of violence to someone?
Representative McLean, will you tell me page and line?
Page 2. Line 6 begins Section 2.
Oh, gotcha. Okay.
And then it says in line 16, in determining whether to issue an extreme risk protection order, the court shall consider the following, colon. Now, if you basically say, let's say we have someone who is not suicidal at all, suffers no mental illness, no mental difficulty, no PTSD, but the fact is they have a history of violence and have shown to have threatened violence against somebody, or that could not this still be applicable under the language of Section 2 nevertheless?
Madam Chair, Representative McLean, I believe you are correct. This bill does not require someone to be suicidal. It is a threat to self or others, is the standard by which the court shall use. So I guess I wouldn't even necessarily agree with it. The person has to have demonstrated violence. It says they could be a threat to self or others. It doesn't say they have to demonstrate that via having tendencies of or exhibited violent behaviors. You see in that list between lines 16 and 37, the issues the court shall use when making that determination, one of which is attempting to have bought a gun or ammunition in the last 180 days. So that in itself is or another one is DUII. Neither of those, I would say, would demonstrate violence toward others or self, but yet those would be factors the court is required to take into consideration under this bill.
Madam Chair, may I ask one last question? So therefore, is it fair to characterize your opposition of this bill as that it could apply to a knife or a whole series of what could be a deadly weapon to prescribe someone from not only possessing but even owning? And it's not based upon anyone's propensity to do harm to themselves, but could even apply to somebody who meets factors of number 4. Therefore, it is in the opposition of NRA that this is over-inclusive, if not vague, in its language.
Madam Chair, Representative McLane, we clearly feel it's over-inclusive. I don't know that I would say that it's vague. It seems pretty specific, and it calls out specific items that will be considered, and many of which show no, or in our opinion, have no correlation to being violent or self-destructive to oneself. I mean, owning a firearm or attempting to purchase a firearm, it is no indication of violence or or suicide. DUII is no indication of violence or suicide. So while it's certainly over-inclusive, it seems pretty specific in areas also.
Well, and if I may follow up, well, I can appreciate that. Perhaps I would see it as vague because it doesn't give sufficient notice to people on what is the prescribed behavior and what items could be seized as a result. And so without having declared that with sufficient specificity, it could be deemed to be unconstitutionally vague. So I thank you for letting us at least make some legislative records so that folks who are rights are abused by this new state authority at least have some grounds to know that part of the opposition was raised in the legislature during committee. Thank you.
Roger, I have a question for you, though. On Section 2, it says, to Vice Chair McLane's point, that the court shall consider the following, including subsection 8, any additional information, but none of those things are dispositive. So the court can consider them, but none of them force the restraining order, as I read it. So these are factors that the court shall look at, but that doesn't mean that they have to rule on any particular way once they look at it.
Madam Chair, it certainly appears that the court can use the simple attempted purchase of a firearm as a qualification to impose this order, as they can with a DUI.
Well, they can consider it.
But they're not prevented from simply considering it and creating the order based only on that.
Madam Chair, in response to your question, yes, you are correct. It doesn't say they have to. If someone has attempted to buy a firearm within the last 180 days, they will automatically lose their rights. It doesn't say that. But that is a factor, and that may be the only factor that the person has to, or that the judge has to consider. It doesn't say you have to consider all of them.